So guys, welcome to my next lecture. On today's lecture, I'll be discussing about 3 cases that further explains the indoor management rule. So starting with the first case. The first case in today's lecture will be the case of Morris versus Kanssen. Morris and Kanssen. K and C were the only directors and shareholders of the company. C falsely alleged that there was a board meeting where S was appointed as director, but no such meeting held, and the minutes of the meeting were forged. At another meeting, S and C, without K's knowledge, purported to appoint M a director, and also the 3 S, C, and M then allotted shares to M. Do you understand? M knew what K intended. M also knew that S wasn't a director. M also knew that the issue of shares was void, but he made no inquiry. Now, he wanted to rely on the indoor management rule, but the court stated that he could not rely on the indoor management rule because he was an insider, a purported director, and it is his duty to know the correct procedure from appointment. According to the House of Lords on the rule in TURQUAND case, person contracting with a company and dealing in good faith may presume act within the Constitution, that's the Articles and Memo, and powers have been properly and duly performed, and aren't bound to inquire whether these acts of internal management have been followed. However, this rule does not apply when you are part of the internal management of the company. In this case, M is part of the internal management of the company. M therefore cannot say that he did not know that the internalities of the company were not complied with when the shares were issued to him. That is not possible, because according to the TURQUAND case, there must be good faith. The basis of the presumption of regularity is on good faith. That third parties, after reading the articles and memo, have good faith in the company that such requirements in the articles and memo and be duly complied with. So moving on to our next case of Mahony versus East HALYFORD mining. In this case, the articles of the company provided that check shall be signed by 2 directors and countersigned by the secretary. It later came to light that neither the directors nor the secretary who signed the check was properly appointed. Now, the judgment of the court was that the bank in this case was entitled to accept the check drawn and signed by directors in manner authorized by the articles, and the bank wasn't obliged to inquire whether individuals signing the check were validly appointed as directors. The person receiving such check shall be entitled to the amount, since the appointment of directors is a part of the internal management of the company, and the person dealing with the company is not required to inquire about it. When there are persons conducting the affairs of company in manner which appears to be in perfect line with the article. I love this sentence. When there are persons conducting the affairs of company in manner which appears to be in perfect line with the articles of association, then those dealing with them externally aren't to be affected by any irregularity which may take place in the internal management of the company. Now, before we get to the last case, I want to discuss the 2 cases that we have spoken about in line with 2 things that I coined for you to have better understanding of this indoor management rule. Then you have to read the fact of each case in line with 2 things: the ostensible conduct and the non-ostensible conduct. Now, the non-ostensible conduct is the one that requires the presumption of regularity. The ostensible conduct is the one that requires the constructive notice rule. Do you understand? When you look at the case of Royal British Bank versus TURQUAND, what is the ostensible conduct? The ostensible conduct is the fact that the seal of the company must be affixed on the bond before the bank can grant the loan. The non-ostensible conduct is the fact that before the company's seal can be affixed on such bond, there must be a resolution. Now, it is the non-ostensible conduct that the presumption of regularity will apply. For the non-ostensible conduct, there is a presumption that regularity has been done. However, for the ostensible conduct, there is a constructive notice on the bank. Do you understand? Now, when we go to the next case of Morris versus Kanssen, the court there is saying that no, this is an exception. Where you are part of the internalities of the company, you cannot start shouting ostensible and non-ostensible. So we'll discuss about this Morris versus Kanssen better in the exception. Let's go to this next case, Mahony versus East HALYFORD mining. Now, in this case, what is the ostensible conduct which constructive notice will be bound on outsiders? The fact that checks must be signed by 2 directors and a secretary. That is the ostensible conduct. But what is the non-ostensible conduct? The non-ostensible conduct is the fact that those directors and those secretary must have been appointed properly. Now the question is there any way outsiders will know about this non-ostensible conduct, so much so that it would be bound on them? It is the opinion of the court that there is no way that third parties will know, which is the reason for the presumption of regularity. However, when it comes to the ostensible conduct, yes, third parties can know because it is written in the articles. But for non-ostensible conduct, resolution has to be passed. A lot of things has to be done in the company. You don't expect third parties to be entering the company every time. Hey, okay, have you passed the resolution? Have you done this? Have you done that? Have you? No. I mean, they themselves are a company and they are operating on so many things. So if they have about 1,000 clients, do you expect them to have somebody go to each of the companies to know whether or not this particular bond that is in front of me has been affixed using the proper resolution, or this particular check has been signed by directors who were properly? No, now. Do you understand? So I need you to understand the reasoning of the court. Let us go to our last case and then apply this ostensible conduct and non-ostensible conduct. In the case of Freeman and Lockyer versus BURCHURST Park Properties, I'm very sure you're already familiar with this case as we talked about it in act and liability of officers of a company. Now, articles contain power to appoint managing director, but none was appointed. K, one of the directors, acted as managing director and engaged a firm, that's the plaintiff, of architect to do work for the company. The court held that the company was bound to pay the architect's fees. The act of engaging architect was within the usual authority of the company, and plaintiffs did not have to inquire whether persons with whom they are dealing with was properly appointed. It was sufficient that under the articles there was in fact power to appoint him, and the board of directors allowed him to do such act. Now, just like I said, what is the ostensible conduct here? The fact that a person acting as a managing director is capable of such powers according to the articles. The articles say that either of the directors can be managing director. Now, there is no way that the third party in this case would know that this person was not properly appointed as managing director. Do you understand? That's the ostensible conduct. Now, the non-ostensible conduct is the fact that the person is supposed to have been validly appointed, which is the argument of the other party that he was not validly appointed, therefore he could not have been acting for the company. But the court said no, that falls between the non-ostensible conduct of the company. And when it comes to the non-ostensible conduct, third parties can presume that regularity has been done. That is why it is the presumption of regularity. So I hope you understand this. Now, if you look at, case laws and all that, you will realize that there is nothing called ostensible conduct and non-ostensible conduct. While I was reading these cases, to make my students understand better, I decided to devise the difference between the ostensible conduct, which falls under constructive notice, and non-ostensible conduct, which falls under presumption of irregularity, so that you would understand it is only for the ostensible conduct that the company would not be bound, because there is constructive notice. But when it comes to the non-ostensible conduct, the company will be bound, and there is nothing like constructive notice. Do you understand that? So therefore, let us go to our next lecture, which is the Australian position on this subject matter. See you in next class.